Thank you for joining me today. My name is Cherish Dela Cruz, and I help busy female practice owners create comprehensive life and business plans that prevent unnecessary stress during life's unexpected events. Today, I want to talk to you about some difficult and challenging topics. This is watching your loved ones age. This may be your parents, family, friends, aunts, and uncles. Today in this Beyond the Mask series, you are going to learn what you need to know to help your aging parents or other loved ones. The US population is aging. Today, there are more than 46 million older adults that are age 65 and older living in the US. By 2050, that number is expected to grow to almost 90 million. This means by 2030, 1 in 5 Americans is projected to be 65 years and older. Now, what does this mean for you and your family members? As I watch my mother, who is 75, get older, and all of my aunts and uncles, I see the differences between families that have chosen to establish a plan and those who don't. The stress that is associated when your loved ones have to deal with older parents who might not necessarily have a plan can be very stressful, time consuming, and expensive. I want to guide you today through the most common elements of what should be put in place. What is estate planning? Essentially, estate planning is choosing who you want to take care of your affairs in the event that you pass away or if you were to get sick. So you may do this in a number of ways. One of them is through a will. A will may be a relatively simple document that sets forth your wishes regarding the distribution of your property. It also includes instructions regarding the care of minor children. But an estate plan goes much further than a will. Not only does it deal with the distribution of assets and legacy wishes, but it may help you and your heirs pay substantially less in taxes, fees, and other court costs. And also, a well-crafted estate plan may prevent conflict among potential heirs and beneficiaries. Now, just as yourselves in doing your own estate planning, your parents or your older loved ones should also have a legal foundation in place. So today I'm going to talk about what those basics are and what happens if they don't. Now, some components of a good estate plan may include a will or a trust, some type of medical power of attorney, a power of attorney for financial, a HIPAA release. However, all of this must be customized for you and your family and their business situation. Now, when working with us, we help you pick the right people and walk you through the process of who will take care of you or your parents or your loved ones if something happens to them. So going back to the basics, a will is a written document with instructions for disposing of one's assets after death. A will can only be enforced through probate court. Now, a trust, on the other hand, think of that like a bucket. It is a contract between you and the beneficiaries. You have to fund that trust, and it's more complicated, but it is also private and isn't subject to probate court if properly funded. Now, a power of attorney, which is critically important for older adults, is a legal document that gives someone legal authority to sign your name on your behalf in your absence. It will discuss and outline who that individual is, who the secondary person is if the first agent that you choose is no longer around, and it outlines what that agent can do in a financial capacity. Now, a medical power of attorney, think of this as a legal document that lets you give someone else the authority to make healthcare decisions for you in the event that you are unable to make them for yourself. This may be the most important and critical decision that I've seen in all of my cases. Sometimes it's called a healthcare proxy or a medical power of attorney. Here in the state of Georgia and also in Florida, if you do not pick the individual who you want to make those healthcare decisions for you, a court will make that choice for you. And you never want that to happen, especially when you're dealing with your aging loved ones. Now, in the healthcare decisions, in the medical power of attorney, it identifies who the decision makers are. Take, for example, in my parents' case, my parents have listed my sister and myself as the individual who would be able to make those medical decisions on my parents' behalf if they were unable to speak for themselves medically. Under HIPAA laws, we wouldn't be able to access any of their medical information or discuss my mother's or father's medical case with them if we did not have this in place. This healthcare power of attorney also has a clear statement of intent to loved ones. Where I've seen this come into play and where it can cause a lot of confusion is when you don't have this medical power of attorney. Family members are guessing what you want to happen in the event that you develop dementia or that you needed some type of medical care, or how you want to be treated and what kind of medical and life-saving measures would you want to be taken on your behalf. And so this also goes to the end of life directives. You know, you can choose as many interventions as you want, or you can ask to just have a natural death. It all depends on what your healthcare choices are, but also having those important discussions with your aging loved ones. I know it may be a difficult and challenging conversation, but it's better to have that conversation beforehand so that they're not conflicting with your parents' wishes. Also, it can avoid guardianship proceedings. Now, a guardianship proceeding is when the court decides who will make those long-term care decisions on your parents or aging loved one's behalf. This is very costly and can cost anywhere from $5,000 and up. And this could all be avoided by making these healthcare decisions when your parents are both of sound minds and can make the decisions by themselves. Now, if you don't have a power of attorney, the court, and there is a dispute between you and your sisters or brothers, or there's a dispute where your parents can't take themselves, aren't able to take care of their financial measures themselves, it can create a lot of problems. Here in Georgia, A financial power of attorney can avoid conservatorship. Conservatorship and guardianship, like I said before, is very time consuming. You have to go to the probate court, and it's very expensive. Probate fees right now for an appointment of a guardian and conservator in and of itself can cost anywhere from $500 or more, depending on the court that is involved. It's very cumbersome, it creates delays, it can cause a lot of conflict between you and your siblings or other loved ones. Essentially, it's public record, and you need to make sure that your parents are choosing the right individual to be the agent for the financial power of attorney. Because as parents are aging or other ones are aging, they may lose their capacity over time, and their risk and exposure to financial senior abuse rises. Now, another issue that you definitely want to talk to your parents about is long-term care. Now, as doctors and physicians, you know what long-term care is. This is when an individual does not have the ability to take care of themselves and to do the activities of daily living. Now, the statistics show that 1 in 2 women and 1 in 3 men over the age of 65 will need some type of nursing home care. Now, here in Georgia, the average cost is about $6,800 a month in Georgia for a private room. But this is a factor that you need to consider. And you need to consider all options for how your parents or your other loved ones are going to pay for it. Is it going to be private care, private pay out of pocket, or do you have long-term care insurance? Can your parents qualify for long-term care insurance right now? Or is Medicaid an option for them? These are difficult and challenging conversations, but it helps to have those conversations ahead of time. It alleviates stress, and you can start the conversation with your parents as in how to, have these conversations. And it might be, hey, Mom and Dad, I just listened to this new this seminar, and it taught me how, or it raised the issue of how, what's going to happen to you if you were to get sick. You need to discuss these goals with your parents and how they want to be treated, no matter how difficult it may be. It's better to be prepared than not prepared. So to recap, it's important to have the conversation with your parents about the essential elements that they should have in place to protect themselves, but also to protect the family and to preserve family and preserve harmony in the family. You can do this by creating an estate plan with either a will or a trust, making sure your parents have an advanced health care directive and a financial power of attorney, and that they choose the right individuals to fill the proper roles. It may be you, it may be your sister or your brother, or another individual who can help your parents during this trying time. Now, if you want to learn more information, or if you want to schedule a complimentary consultation, you can reach out to me at 770-687-8813, or reach out to me at my email address, cherish@delacruzlaw. Thank you for being here today.